but then changes are headed this way. Welcome back.
All right, we've been talking about this throughout the morning. This morning, this draft report that came out about John Gardner and the procedures that took place with him as far as his incarceration when he was first arrested.
Exactly. And lawmaker Nathan Fletcher is joining us here, who obviously has jumped in with both feet on this issue with Chelsea's Law. Good morning to you, sir.
Good morning.
How are you?
Good.
All right, let's talk about this report. It's on the front page of the local paper, the Union Tribune. It kind of outlines what's happening. But as a result of the Gardner case and Chelsea King, a big report has come out. And basic findings, what has it said?
Well, it says a number of things. I mean, it identifies a lot of critical shortcomings and actually proposes solutions. And this has been a part of the review process we've done. What are the things we can do to make it work better? And I think there were a lot of good recommendations. The creation of safe zones, you know, limiting where sex offenders can go. I talked about dynamic modeling in terms of risk assessment tools, something we had a hearing on in Poway a week or so ago.
What does that mean?
Well, so that means prioritizing your resources on the most dangerous, the most likely to reoffend. You know, our resources ought to really be focused on those we are afraid of, not those we're mad at. And so making sure that we're making that distinction. And then so there were a number of ideas that came out of it I think are good that we'll try and implement.
Let's talk about the safe zones, because right now there are laws restricting where sex offenders can live, and that is pretty recent, actually. But you want to maybe increase that. How so?
Sure. Well, so the law from 2006 says you can't live within 2,000 feet of a park. But there's nothing in the law that says if you're a registered sex offender or if you've violently assaulted a child in the past, it says you can't live near that park. It doesn't say you can't go in that park, which doesn't seem to make any sense. I care less about where you live and more about where you go. And so we're looking at loitering statutes or trespassing laws to say, you know, without approval of a parole agent, you can't go in that park. That way parents have some level of comfort of knowing if you take your child to a park, there's not going to be sex offenders roaming around.
Would that have included the jogging park where Chelsea...
Yeah, I think you expand it to any parks where children congregate, and children being anyone under the age of 18.
Would that be tough to legislate because of the ACLU and organizations like that who say this could violate someone's rights?
Well, I think if you sexually offend a child, you give up some of your rights.
Yes.
So I wouldn't be concerned. But from a legal standpoint, when we ask that question, there's a lot of precedent for this with gang injunctions, with other types of things that limit and restrict where someone can go.
And now, what about the record situation with Gardner? Apparently, these records disappeared somehow mysteriously, and according to current law, you don't have to hold on to the records that long. This would change that.
Well, and this was one of the most shocking things we saw as we tried to do the review, that corrections had destroyed the records, which made no sense. The governor ordered them to stop the destruction, and this calls for preservation of records, not only by corrections, but by all law enforcement for a period of at least 75 years. You know, I think 75 years indefinitely are things we're looking at statutorily required.
Why were things destroyed in the first place? Was it just logistics, not having enough space to keep things?
I've been in office about a year and 3 or 4 months, and I've heard a lot of dumb things. This was the dumbest. They said they didn't have enough filing cabinets.
Filing cabinets.
We put a man on the moon 40 years ago. I said, well, do you need a scanner? I mean,
there's these new things called computers.
We should maintain these electronically.
Yeah, exactly.
So I don't think there's any justifiable reason for the destruction of records.
All right, we want to talk about Chelsea's Law. How is that coming, and what is the next step?
So we're narrowing it. You know, we've kind of outlined the 3 areas. You know, the basic premise of if you violently sexually assault a child and you're a danger to reoffend, you should never get out. So a life without parole option. The second one, which the Sex Offender Management Board report mentioned, was potentially lifetime parole for those that are at the worst, the greatest likelihood that maybe don't qualify for life without parole, but we want to keep an eye on them. And then the third area is the safe zone. So next week we'll be rolling out the exact specifics, exactly what it means, what sections of the code it would apply to. And then we'll begin the process of trying to pass it legislatively.
If there is a lifetime of parole, would there be a way to monitor these people? Because obviously if they're just out running around.
Great question. So current law requires lifetime GPS for all sex offenders. The problem is that law didn't distinguish what entity is actually charged with enforcing it, so it doesn't happen. And so if you keep sex offenders on parole for life, then the Corrections Department and parole is in charge of them and will be responsible for GPS monitoring.
All right.
But we want to focus it at the worst, the most likely to reoffend.
Absolutely. All right, Nathan Fletcher, thanks for joining us here this morning. Best of luck.
Thank you.
You certainly, in a year over at the legislature, have, you know, gotten in with both feet. So appreciate it.
Thank you.